This is the audio notes for Indian Polity, and this is chapter number 1, the President of India. The President of India is the head of the Indian state, and the article from Article 52 to 78 of the Part 5 of the Constitution deals with the President of India. The President of India is elected by the elected members of both the houses of the Parliament. The elected members of legislative assemblies of states plus the elected members of the legislative assemblies of Delhi and Puducherry. Value of vote of an MLA. Total population of the state divided by the total number of elected members in that state legislative assembly whole multiplied by 1 by 1000. Value of the vote of an MP. Total value of votes of all the MLA of all states divided by the total number of elected member of parliaments. Next subheading, qualification. The qualification of Indian president includes that he should be a citizen of India, his age should be more than 35 years of age, he should be qualified for election as member of Lok Sabha, he should not hold any office of profit. The oath of the office of President is administered by the Chief Justice of India and in absence by the senior most judge of Supreme Court. His emoluments and allowances can't be diminished during his term of office. President enjoys personal immunity from legal liability of his official acts. He also is immune from any criminal proceedings, even in respect to personal act. He can't be arrested. Next subheading, term of President's office. The term of President's office is 5 years. He can resign from his office any time by addressing the resignation letter to the Vice President. He is also eligible for re-election to that office after the expiry of his term. In case of any delay in conducting the election of new president by any reason, the outgoing president continues to hold office. Next subheading, Impeachment of President under Article 61. Charges can be initiated by either house of the Parliament. 14 days notice has to be given to the President. It needs two-third majority in both the houses of the Parliament for the impeachment. Impeachment is a quasi-judicial process. Subpoints. The nominated members of both the houses can participate, though they do not take part in the election. The elected member of legislative assemblies of states and Union Territory of Delhi and Puducherry do not participate, though they take part in the election. Next subheading, vacancy. In delay of election of new president, vice president does not get the opportunity of acting as president. If vacancy occurs due to resignation, removal, death, or otherwise, then vice president acts as a president. Next subheading, executive powers. All executive actions are formally taken in his name. The President appoints Attorney General of India and determines his remunerations and holds office during President's pleasure. He also appoints Comptroller and Auditor General of India. He appoints Chief Election Commissioner of India, Election Commissioner of India, the Chairman and members of UPSC, the Governor and the Chairman of Finance Commission. He appoints Commission to investigate into condition of scheduled caste, scheduled tribes and other backward classes. He directly administers the state union territories through administrators appointed by him, can declare any area as scheduled area and has power to administer it. Next subheading, can summon legislative powers, can summon or prorogue the parliament and dissolve the Lok Sabha, can also summon the joint sitting of both the houses of parliament, preceded by the Speaker of Lok Sabha, can appoint a member of Lok Sabha to preside over its proceedings in the absence of Speaker and Deputy Speaker, and similar in case of Rajya Sabha. He nominates 12 members to Rajya Sabha and 2 members to Lok Sabha from Anglo-Indian community. Need prior permission for certain bills that are introduced in the Parliament from the President of India, which includes the bill involving expenditure from Consolidated Fund of India, alteration of boundaries of states or creation of new states. If a bill is sent to President after passing from both the houses, then he or she under Article 111 have 3 options. Number 1, give his assent. Number 2, withhold his assent. Number 3, return the bill. If passed again, then have to sign it. A bill from state legislature reserved by governor also has 3 options. Give his assent, withhold his assent, ask the governor to return the bill and not obligatory to sign it if sent again. Next subheading, financial powers. The money bill can be introduced in Parliament only on prior recommendation of President. Constitutes a finance commission after every 5 years to recommend the distribution of revenue between center and states. He appoints the Chief Justice and judges of Supreme Court and High Courts. Next subheading, emergency powers. There are 3 types of powers. Number 1, national emergency under the Article 352. Number 2, President's emergency under Article 356 and 365. Number 3, the financial emergency, Article 360. Next subheading, veto powers of President. Number 1, absolute veto without withhold assent. With respect to private members' bill or the government bills when the cabinet resigns and new cabinet advises not to give assent. Next is suspensive veto, when he returns a bill for reconsideration to the parliament. Next, pocket veto. The president can neither ratify nor reject nor return the bill, but simply keeps the bill pending for an inadequate time. Following this, there is 24th Constitutional Amendment Act 1971 made it obligatory for the President to give his assent to the bill. President veto over state legislature. Bill presented to the governor first and he has 4 alternatives under Article 200. Number 1, to give assent. Number 2, to withhold his assent. Number 3, return the bill for reconsideration. And number 4, may reserve the bill for the President's consideration. Then, the President holds 3 alternatives under Article 201. Number 1, to give assent. Number 2, to withhold. Number 3, return the bill for the reconsideration. But the President is not bound to give assent if sent again. Next subheading, audience making powers. Under Article 123, promulgation of ordinances during recess of Parliament, it has the same force as an Act of Parliament. Limitations. Number 1, only when both or at least one house is not in session It is not a parallel power of legislature. Number two, he can make an ordinance only when he is satisfied that the circumstances exist that render it necessary to take an immediate action. Under 44th Constitutional Amendment 1978, the President's satisfaction is justifiable on the grounds of malified. That means it can be challenged in the Supreme Court. Number 3, can be issued to only those subjects on which the Parliament can make law. And an ordinance can't abridge or take away any of the fundamental rights. Number 4, every ordinance issued must be laid before both the Houses of Parliament. After the approval, it becomes an act. Ordinance seeks to expire within 6 weeks from assembly of Parliament. However, it can't be used to amend the Constitution. Next heading, pardoning power of President under Article 72. This power is independent of judiciary. Pardon removes both sentences and convictions and completely free from all punishment. Commutation, substitution of one form of punishment to lighter form. Remission, reduce the period of sentence without changing his character. Respite, it denotes awarding lesser sentence due to special fact like physical disability or pregnancy of a woman offender. Reprieve implies a stay of execution for a temporary period. Under Article 161, the governor also possesses the power of pardoning and can grant reprieves, respites, and remissions. Exceptions. Number 1, President can pardon sentences inflicted by court martial while governor cannot. Number 2, the President can pardon death sentences while governor can't. 42nd Constitutional Amendment 1976 made the President bound by the advice of the Council of Ministers headed by the Prime Minister. 44th Constitutional Amendment 1978 authorized President to require the Council of Ministers to reconsider such advice either generally or otherwise. The President may return a matter once for reconsideration, but reconsidered advice will be binding. The President can act on his discretion under following situations. Number 1, appointment of Prime Minister when no party has a clear majority in Lok Sabha or in case of death. Number 2, dismissal of Council of Ministers when it can't prove the confidence in Lok Sabha. Number 3, dissolution of Lok Sabha if Council of Ministers has lost its majority. Important articles of the chapter: Article 54, election of President; Article 60, oath of the President; Article 61, impeachment of President; Article 65, Vice President act as Presidents; Article 72, power to grant pardons; Article 76, Attorney General of India; Article 85, session of Parliament, prorogation and dissolution; Article 111, assent to bills; Article 112, annual financial statement; and Article 123, to promulgate ordinances. Thank you.